There's been a curious judgment which has caused a little bit of a fuss in GB News and other right-wing media. And I find it puzzling, the facts, the law, the optics, and the lessons that this story engenders. In April 2024, the first-tier tribunal judge, Fiona Beach, allowed Christian Conjovi, a French national who arrived in the UK at the age of 10 and has a record including sexual assault as a child, knife carrying, and drug dealing, to avoid deportation. She concluded that he was a genuine, present and sufficiently serious, that he was not a genuine, present and sufficiently serious threat to public security, and worried that he would reoffend if dropped in France with few ties. The upper tribunal later overturned her decision for a material error of law, finding that she had not adequately justified why he posed no present threat. And the controversy intensified when newspapers noted that Judge Beach had previously been a director of asylum aid and had volunteered for bail for immigration detainees years before joining the salaried judiciary. Robert Jenrick called this an apparent conflict of interest and asked the JCIO to investigate. Whatever one's politics, those bare facts set the stage. Now, two frameworks matter. The first is the idea, which is developing, of automatic deportation for non-British, non-Irish offenders sentenced to at least 12 months in prison. The Home Secretary is now obliged to make a deportation order subject to statutory exceptions and human rights. That is Section 32 of the UK Borders Act 2007. EU citizens with status for EU nationals protected by the post-Brexit saved EEA regime, removal must meet the higher test that conduct represents a genuine, present and sufficiently serious threat to public policy or security. Past convictions are relevant but not enough on their own. That is the Bocheru line of authority preserved in the UK by saved regulations and Home Office guidance. And overlay that with Article 8 of the ECHR proportionality, and the tribunal must weigh the public interest in deportation against private and family life with structured rules and thresholds, including very significant obstacles to integration abroad. The Home Office's own guidance is blunt that a lack of a job or general hardship overseas will rarely meet the bar. And that's where this legal curiosity appears. The tribunal's written reasons, as reported, emphasise that in France, the appellant would have had no accommodation, few ties, and might slip back into drug dealing, hence remaining in Britain was safer. But the saved EEA test is about risk to the UK public of offending in France after removal, and Article 8's obstacles to integration is not satisfied by ordinary employment or housing difficulties. The upper tribunal's finding of a material error of law is therefore unsurprising. The optics here, the apparent bias and the judicial ethics make one question whether the judge, did her past charity roles require some sort of recusal? The binding test would be Porter versus McGill, and would a fair-minded and informed observer conclude that there's a real possibility of bias? Prior work in a charitable field is not disqualifying per se, and the official guide to judicial conduct explicitly permits community and charitable involvement with two caveats: to maintain independence and avoid roles that create a reasonable apprehension of bias and declare any conflict. That's the standard against which any judge will be judged. On the facts in the public domain, this judge's asylum aid directorship ended in 2007, long before her 2018 salaried appointment and the 2024 appeal. But remoteness in time matters to the fair-minded observer, and but the perception problem is real in heated policy areas, and that's why transparency around declarations is so important. First-tier judges make hard, fact-heavy calls, and the upper tribunal doesn't retry the facts, it corrects errors of law. Hence, is this the right yardstick to apply? Has it been applied in the wrong way? Specifically, is the conclusion tied to the evidence? Is the conclusion that this fellow presented no risk tied to the evidence? And the press shorthand is that the decision seems to be questionable, and hence the flurry of interest in GB News and elsewhere. The legal reality is that there may be an error of law, and simply the effort to examine this shows that the system is working. But there are deeper principles at stake, and I must say I'm rather heartened by this story, because it shows to me that we are prepared to take responsibility for people who have erred under while they are under our control, and that we ought to fix the problem before sending them back. I don't think I don't think we should send someone to France if we know they're going to be dangerous. Parliament has, of course, spoken plainly. Deportation is in the public interest where thresholds are met. Guidance stresses deterrence and public confidence, even where the individual risk is lowered by remorse or rehabilitation. The first tier's judge's emphasis on reintegration difficulties abroad ran against that grain. The fact that this fellow had arrived in Britain as a child complicates things. Long residence from childhood can weigh heavily under Article 8. The Maslow and the Una criteria remind courts to consider the length of stay, family ties, and the seriousness of offending. But even then, proportionality is structured and doesn't license a freestanding welfare audit of the destination country. Judges must be independent and must be seen to be so. The guide encourages community service but warns against lending judicial prestige to contentious organisations or creating a perception of predisposition. That's not a gag on past professional life. It's a call for candour and for caution. So I think the tribunal may have gone wrong initially. It substituted a French or of a Franco-centric hardship analysis for a UK-centric risk analysis under the saved EEA regime. It treated ordinary reintegration problems as if they were very significant obstacles, contrary to published guidance which says a lack of employment and general hardship rarely meet that threshold. It didn't explicitly reconcile the statutory public interest in deportation with its conclusion that present risk was low, leaving the UT to find a material error of law. So, what should change? We need probably mandatory searchable declaration registers for tribunal judges. We already have ethical duties. We need to make the declarations routine and visible so criticisms can be answered with facts, not innuendo. We need sharper reasons. We need templates in protection and for deportation appeals. We need we should require a discrete section headed "Present Risk to the UK Public: Findings and Evidence," separate from Article 8 and integration abroad, and that would force discipline and reduce error of law appeals. And we need probably more targeted training on post-Brexit action, what to do within the post-Brexit framework. Too many judgments still slide between the Borders Act logic and saved EEA logic. The Home Office guidance is clear, the reasons should be too. And we need to publish more upper tribunal error of law decisions promptly. Sunlight improves first instance consistency and public confidence. The case is not proof that what GB News would call activist judges are running the system. It's proof that standards are high, scrutiny is fierce, and the appellate correction exists. The judge applied a generous view of reintegration hardship. The upper tribunal said that that was not the law, but that means the law is not clear. That means the law needs clarity, needs qualification. Meanwhile, the ethics framework already demands independence in fact and appearance, and it gives us the tools to police both. We need to use them, we need to tighten reasoning, we need to keep the public interest at the centre of the analysis. That is how you protect the public, and that's how you protect judicial legitimacy at the same time. And a lot of the stuff that we've seen on GB News and a lot of the noise being made by people like Robert Jenrick needs to be dismissed and treated as it is, which is just noise. The judicial review here, the review of the judge's decision, is the right one. And I think in this particular case, there may have been slightly more leniency than perhaps was intended in the law, but I think the right call has been made, and if the law is not tight enough, it needs to be tightened.